Hello students and welcome to the lecture. So students, basically in this lecture, we are going to start the discussion over the citizenship. Alright. And in this particular decision, basically you can say that these are the topics we have scheduled for the discussion. Like starting with the meaning and significance, constitutional provisions, single citizenship, and overseas citizen of India. Alright. These are the topics which we have scheduled for the discussion under this particular series. Alright. So let's first starting with the meaning and the significance part. Alright. So what do we mean by the citizenship and what is the meaning of citizenship and significance when we talk about the Indian context? Alright. First is, like any other modern state, India has two kind of peoples, like the citizens and the aliens. Okay, citizens and aliens. Citizens are full members of the Indian state and who allegiance to it. It means that citizens are those members which having all the rights, all the facilities the India provided for its people, and they also have to you can say discharge all the duties and responsibility towards the nation. They enjoy all the civil and the political rights which prevail in the country and allowed for the citizens to have. Aliens, on the other hand, are the citizens of some other state and hence do not enjoy all the civil and the political rights. Got it? And basically, there are of two categories, like friendly aliens. Second category is enemy aliens. All right. Friendly aliens are the subject of those countries that have cordial relations with India. All right. Basically, you can say that friendly aliens, or you can say the word alien is basically used for the outsider, the person who does not belong to the country. All right. And basically, we further divided the aliens into the two categories named as friendly aliens or in the animal aliens. The friendly aliens are those aliens which belong to those countries that India is friend with. All right. And the enemy aliens, on the other hand, are the subject of that countries that is at war with India, or you can say generally the relation of India is not so good with them. All right. They enjoy the lesser rights than the friendly aliens. Example, they do not enjoy protection against arrest and detention. All right. So basically, you could say that there is an Article 22, which is a part of fundamental rights. Okay. Which are the part of fundamental rights. And this gives the protection against arrest and detention. All right. So the people who are the outsider, but they belong to the country of India, these are called the friendly aliens. They do not enjoy any. They do enjoy the protection against the arrest and detention. But those who belong to the enemy aliens are those peoples who having, or you can say who having the domicile and who belong to that country, the India is not friend with. So basically, they are not eligible and they do not enjoy the protection against arrest and the detention as the friendly aliens do. The Constitution confers the following rights and privileges on the citizen of India and denies the same to aliens. It means that the person who belong to the country of India, and you could say the person is the citizen of India. So these are the rights which are allowed to that person to have. And these are the rights which are denied to the aliens. Got it? First, right against discrimination on grounds of religion, race, caste, sex, or place of birth, Article 15. All right. It means that no person could be discriminated on the grounds of religion, race, caste, sex, or place of birth as per the power of Article 15. Thereafter, right to equality of opportunity in the matter of public employment. It means that whenever the person wants to join the public services, the person will have the equal opportunities. This is allowed by the Article 16. Thereafter, right to freedom of speech and expression, assembly, association, movement, residence, and profession. These are the 6 freedom rights which are provided under the Article 19, and these are allowed to the citizen of India. Thereafter, cultural and educational rights. Cultural and educational rights, which are provided by Article 29 and 30. Thereafter, right to vote in elections to the Lok Sabha and State Legislative Assembly. All right, this is also for the citizens only. Right to consent for the membership of the Parliament and the State Legislature. This is only for the citizens. Eligibility to hold certain public offices like the President of India, Vice President of India, Judges of the Supreme Court and the High Courts, Governor of the States, Attorney General of India, and Advocate General of State. If any person wants to hold this particular office, then the person must be the citizen of India at any cost. All right. Along with the above rights, that citizens also owe certain duties towards the Indian state. Like, for example, they are required to pay taxes on time, respecting the national flag and the national anthem, and defending the country, and so on. Got it? In India, both a citizen by birth as well as a naturalized citizen are eligible for the office of president, while in USA, only a citizen by birth and not a naturalized citizen is eligible for the office of president. It means that basically in India, the person who is born in India, that is a citizen by birth, and the person who was born outside India then acquired the citizenship of India. Both the cases, naturalization and the birth, the person could be eligible for the president. But when we talk about the USA, then only the person who was born in USA is eligible for the president. The Constitution deals with the citizenship from Articles 5 to Article 11. This is very, very important. Keep this thing in your mind. Article 5 to Article 11 under Part 2nd of the Indian Constitution. Okay. However, contains neither any permanent nor any elaborate provisions in this regard. So basically, I could say Constitution only deals with these provisions. All right, but it does not having any permanent and elaborated provisions in this regard. Okay, only identifies the person who became citizen of the country of India at his commencement on 26 January 1950. Okay, does not deal with the problem of acquisition or loss of citizenship subsequent to its commencement. It means that the Constitution only deals with the acquisition of the citizenship when it was commenced, and basically does not deal with any acquisition after the commencement or loss of citizenship after the commencement. Empowers the Parliament to enact a law to provide such matters and any other matter relating to the citizenship. Okay, accordingly, the Parliament has enacted the famous Citizenship Act 1955, which has been amended from time to time as per the modern requirement. All right. So, according to the Constitution, the following 4 categories of persons became the citizen of India at its commencement. Therefore, on January 26, 1950. All right. A person who had his domicile in India also fulfilled any one of 3 conditions, like he was born in India, he either of his parent was born in India, or he has been ordinarily resident in India for 5 years immediately before the commencement of Constitution become a citizen of India. Okay, so there are the 3 ways. First, he is born in India. Second, his parent was born in India, either father or mother. Third, that he was residing in India for 5 years before the commencement of the Constitution. Then they become a citizen of India. Thereafter, a person who migrated to India from Pakistan became an Indian citizen if he or either of his parents or any of his grandparents was born in undivided India when India and Pakistan were not created, also fulfilled any one of two conditions, like in case he migrated to India before July 1948. Okay, he had been ordinarily resident in India since the date of his migration. Okay, or in case he migrated to India on or after 19 July 1948. All right, he had been registered as a citizen of India. But a person could be so registered only if he had been resident in India for 6 months preceding the date of his application for the registration. Okay, so that is the another thing. A person who migrated to Pakistan from India after 1st March 1947 but later returned to India for resettlement could become an Indian citizen. For this, he had to be resident in India for 6 months preceding the date of his application for registration. It means that if the person is forwarding the application in the month of July, then he must be in India or residing in India from January. So, January to July will be the condition. A person or any of whose parents or grandparents was born in undivided India but who is ordinarily residing outside India shall become an Indian citizen if he has been registered as citizen of India by the diplomatic or consular representative of India in the country of his residence, whether before or after the commencement of Constitution. Thus, this provision covers the overseas Indians who may want to acquire the Indian citizenship, or you can say these are the people who are living outside of India, but they want to be the citizen of India, but as an overseas citizen, not the full citizens. All right. To sum up, these provisions deal with the citizenship of a person domiciled in India, person migrated from Pakistan, person migrated to Pakistan but later returned, persons of Indian origin residing outside India. Okay. So basically, this provision deals with citizenship of these kind. Okay. Those who are already in India, those who migrated from India, those who migrated to Pakistan but later to India after a specific period of time, and the person who originally residing outside India, they could acquire the citizenship as an overseas citizen of India. The other constitutional provisions with respect to the citizens are as follow. First, no person shall be a citizen of India or be deemed to be a citizen of India if he has voluntarily acquired the citizenship of any foreign state. It means that if someone is the citizen of India, then he acquired the citizenship of, for example, Australia, then what will happen? The person will automatically declared as an un-Indian, or you can say his Indian citizenship will be terminated with full effect. Every person who is or is deemed to be a citizen of India shall continue to be such citizen subject to the provisions of any law made by Parliament. All right. Parliament will have the power or shall have the power to make any provision with respect to the acquisition and termination of citizenship and all other methods which are relating with the citizenship. All right. This is another thing. Thereafter, Citizenship Act 1955. The Citizenship Act 1955 provides for the acquisition and laws of citizenship after the commencement of the Constitution. Why? Because we know the Constitution having the provisions from Article 5 to 11, but these provisions does not talk about any kind of permanent citizenship. All right. Originally, the Citizenship Act 1955 also provided for the Commonwealth citizenship, but this provision was repealed by the Citizenship Amendment Act 2003. Okay. Thereafter, another thing which we have the acquisition of citizenship, or you can say ways through which we could acquire the citizenship. The Citizenship Act of 1955 prescribes 5 ways of acquiring citizenship, like birth, descent, registration, naturalization, and incorporation of territory. All right. So these are the 5 ways. First, birth. Second, descent. Third, registration. Fourth, naturalization. And fifth, incorporation of territory. Okay. So basically, let's talk about the first one, which is known as the by birth. A person born in India on or after 26 January 1950, but before July 1, 1987, is a citizen of India by birth, irrespective of the nationality of his parents. All right. So remember these details. These dates are important from the examination point of view. All right. A person born in India on or after 1st July 1987 is considered as a citizen of India only if either of his parents is a citizen of India at the time of his birth. Further, those born in India on or after 3rd December 2004 are considered citizens of India only if both of their parents are citizens of India or one of whose parent is a citizen of India and the other is not an illegal migrant at the time of their birth. Then, thereafter, the children of foreign diplomat posted in India and enemy allies cannot acquire Indian citizenship by birth because their parents will be considered as a foreigner. All right. So it doesn't matter that whether they are born in India or not, but still their domicile will be outside. By descent, a person born outside India on or after 26 January 1950, but before December 10, 1992 is a citizen of India by descent if his father was a citizen of India at the time of his birth. Person born outside India on or after 10 December 1992 is considered as a citizen of India if either of his parent is a citizen of at time of his birth. Thereafter, December 3, 2004 onwards, person born outside India shall not be a citizen of India by descent unless his birth is registered at an Indian consulate within 1 year of the date of birth or with the permission of central government. After the expiry of the set period, an application for registration of birth of a minor child to an Indian consulate shall be accompanied by an undertaking writing from the parents of such minor child that he or she does not hold the passport of any other country. All right. If they having, then the citizenship will not be granted as per the descent. Further, a minor who is a citizen of India by virtue of descent and is also a citizen of any other country shall cease to be a citizen of India if he does not renounce the citizenship or nationality of another country within 6 months of his attaining full age. Okay. Thereafter, another way is by deprivation. It is a compulsory termination of Indian citizenship by the central government if citizen has obtained the citizenship by fraud. All right. Citizen has shown disloyalty to the Constitution of India. Citizen has unlawfully traded or communicated with the enemy during the war. Citizen has within 5 years after the registration or the naturalization been imprisoned in any country for 2 years. And third, and the last basically, citizen has been ordinarily resident out of India for 7 years continuously. So if any of these things has been done by any person who used to be a citizen of India, then the central government will deprive the citizenship of that particular person. Got it? Though the Indian Constitution is federal and envisages a dual polity, like at the central and the state level, but it provides only for a single citizenship, that is the Indian citizenship. Okay. So what is saying here? Like doesn't matter whether in India there is a two type of government. One government is a central level, another government are at state level. But still, in India, basically the citizenship is only granted for two reasons. All right. Or you can say there is only a single citizenship in India. The citizen in India owe allegiance only to the union. Okay. It means that the citizens are only required to follow the constitution. All right. And the rules and the regulations on citizenship will be addressed and maintained by the union or the center. There is no separate state citizenship. All right. The other federal state like the USA and Switzerland, on the other hand, adopted the citizen of double citizenship. It means that if you are living in Texas, which is in the USA, so you are required to obtain the two citizenship. One is for the country, second is for the state of Texas. All right. In USA, each person is not only a citizen of USA, but also of the particular state to which he belongs. Thus, he owes allegiance to both and enjoys dual set of rights, one set conferred by the national government and another by the state government. This system creates the problem of discrimination. That is, a state may discriminate in favor of its citizens in matters like right to vote, right to hold public offices, right to practice professions, and so on. The problem is avoided in the system of single citizenship prevalent in India. In India, all citizens, irrespective of the state in which they are born or reside, enjoy the same political and civil rights of citizenship all over the country, and no discrimination is made between them. However, this general rule of sense is discrimination is subject to the some exceptions. Why? First, the parliament under the Article 16 can prescribe residence within a state or the union territory as a condition for certain employments or appointments in that state or UT or local authority or other authority within that state or union territory. Accordingly, the Parliament enacted the Public Employment Requirement as to the Residence Act 1957 and thereby authorized the Government of India to prescribe residential qualification only for appointment to non-gazetted posts in Andhra Pradesh, Himachal Pradesh, Manipur and Tripura. As this act expired in 1974, there is no such provision for any state except Andhra Pradesh and Telangana. So what happened? That however, Article 16 states that in India, any person who is residing in India is set to free to get the equal opportunities in the public services. But still under Article 16, the government could make the certain provision for certain states in which if the person is going into the public services which are of the non-gazetted nature, then the person is not, the person is required to be the resident of that particular state. Thereafter, the Constitution under Article 15 prohibits the discrimination against any citizen on ground of religion, race, caste, sex, or place of birth, and not on the ground of residence. This means that the state can provide special benefits or give preference to its residents in matters that do not come within the purview of the rights given by the Constitution to the Indian citizen. For example, a state may offer concession in fees for education to its residents. First thing. Third, the freedom of movement and residence under Article 19, subjected to the protection of interest of any scheduled tribe. In other words, the right of outsiders to enter, reside, and settle in tribal areas is restricted. Of course, this is done to protect the distinct culture, language, custom, and manners of scheduled tribes, safeguard their traditional vocation and property against exploitation. Okay? Thereafter, till 2019, the legislature of the East-Valley state of Jammu and Kashmir was empowered to define the person who are permanent resident of state, confer any special rights and privileges on such permanent resident as respects employment under the state government, acquisition of immovable property in the state, settlement in the state, and right to scholarship and such other forms of aid provided by the government. And this was basically done under two articles. Article 370, Article 35A. But we know that on 5 August 2019, both the article were repealed by the government or revoked by the government. So you could say that these provisions are no longer in existence. The our provision was based on the Article 35 of the Indian Constitution. Article was inserted into the Constitution by the Constitution Application to Jammu and Kashmir Order 1954. This order was issued by the President under the Article 370 of the Constitution, which had provided the special status to the East-Valley state of Jammu and Kashmir. In 2019, this special status was abolished by a new presidential orders, which are generally known as the Constitution Application to Jammu and Kashmir Order 2019. This order superseded the earlier 1954 order. Okay, so basically you could say these provisions were introduced in the Constitution by 1954 order and were revoked by the Constitution by 2019's order. Okay. The Constitution of India, like that of Canada, has introduced the system of single citizenship, provided uniform rights except in few cases for the people of India, to promote the feeling of fraternity and unity among them and to build an integrated Indian state. Despite this, India has been witnessing the communal rights, class conflict, caste wars, linguistic clashes, and ethnic disputes. Okay? Thus, the cherished goal of the founding fathers of Constitution makers to build an united and integrated India nation has not been fully realized. So what you could say? That by providing the single citizenship, what we aimed for, that we should provide the equality of status and the rights to the all citizens, irrespective of the state or the area they are residing in, so that the feeling of fraternity and unity amongst them could be built on. But still, there are communal rights, class conflicts, caste war, linguistic clashes, and the ethnic dispute amongst the people. So we could say that the cherished goal behind providing the single citizenship in India, and this goal was of the founding fathers of the Constitution, has not been fully realized, and we have to work on this still. Thereafter, another thing what we have the Overseas Citizen of India. In September 2000, the Government of India, or you can say the specific Ministry of External Affairs, set up a high-level committee on the Indian diaspora under the chairmanship of L.M. Singhvi. All right. The mandate of the committee was to make a comprehensive study of the global Indian diaspora, recommend measures for a constructive relationship with them. All right. Committee submitted its report in January 2002, recommended the amendment of Citizenship Act 1955 to provide for grant of dual citizenship to the person of Indian origin, PIOS, belonging to the certain specified countries, or you can say mostly the friendly countries. Accordingly, Citizenship Amendment Act 2003 made provisions for acquisition of Overseas Citizen of India (OCI) by the PIOS of 16 specified countries other than Pakistan and Bangladesh. Also omitted all provisions recognizing or relating to the Commonwealth citizenship from the Principal Act. Alright. Later, the Citizenship Amendment Act 2005 expanded the scope of grant of OCI for PIOS of all countries except Pakistan and Bangladesh, as long as their home countries all dual citizenship under the local laws. Must be noted here that OCI is not actually a dual citizenship, as the Indian Constitution forbids dual citizenship or dual nationality under Article 9. So remember, OCI is just a you can say recognition we provide to the outsiders or the Indians who reside outside of India, and this is not like any kind of dual citizenship, because the dual citizenship or dual nationality is banned in India. Again, the Citizenship Amendment Act 2015 modified the provisions pertaining to the OCI in the Principal Act, introduced a new scheme which we call as the Overseas Citizen of Indian card holder by merging the PIO card scheme and the OCI card scheme. The PIO card scheme was introduced on August 19, 2002, and thereafter the OCI card scheme was introduced on December 2, 2005. Okay. Both the schemes were running in parallel, even though the OCI card scheme had become more popular. This was causing unnecessary confusion in the minds of applicants, keeping in view some problems being faced by the applicants and to provide enhanced facility to them. Government of India decided to formulate one single scheme after merging the PIO and OCI schemes containing positive attributes of both. Hence, for achieving this objective, the Citizenship Amendment was made and the PIO scheme was rescinded on January 9, 2015, and also notified that all existing PIO cardholders shall be deemed to be the OCI by the January 9, 2015 onwards. Got it? And the Citizenship Amendment Act 2015 replaced the nomenclature of overseas citizen of India with that of overseas citizen of Indian cardholder and made the following provisions in the Principal Act. Like, first is the restriction of overseas citizen of Indian cardholder. Okay. The central government may, on application made in this behalf, register as an overseas citizen of Indian cardholder for any person of full age and capacity who is a citizen of another country but was a citizen of India, time of or at any time after the commencement of the Constitution, who is a citizen of another country but was eligible to be citizen of India at the time of commencement of the Constitution, or who is a citizen of another country but belonged to a territory became part of India after 15th August 1947, or who is a child or a grandchild or a great-grandchild of such a person. Person who is a minor child of person mentioned in clause A, or a person who is a minor child and whose parents are citizen of India, or one of the parent is a citizen of India. Spouse of any foreign origin of a country of India, or spouse of foreign origin of an overseas citizen of Indian cardholder and whose marriage has been registered and substituted for a continuous period of not less than 2 years immediately preceding the presentation of the application. Alright, no person who or either of whose parents or grandparents or great-grandparents is or had been a citizen of Pakistan and Bangladesh or such other countries as the central government may specify shall be eligible for registration as an overseas citizen of Indian cardholder. Alright, so students, basically you could say that in this lecture we had finished the citizenship. Alright, in the next lecture we will start with another important topic. I know that most of you will think that I didn't explain much in this lecture, but believe me, there is nothing like to explain in this particular lecture. Alright, so basically with this note we are going to end this lecture, and thank you.